As unpleasant as it is to lose your job, having your claim for unemployment benefits refused adds an additional element of frustration. In spite of this, don't give up. You are permitted to file an appeal against the decision. Through the use of this video, you will be guided through the process, which will increase the likelihood of a good conclusion. Before making an appeal, it is essential to have a solid understanding of the basis for the decision. Your letter of refusal ought to provide an explanation of the state's reasoning. Among the most common explanations are not having a valid reason for leaving your employment. If the state determines that you left your position voluntarily and without a convincing reason, you will be disqualified from receiving benefits. Should you be terminated due to misconduct that is associated with your work, you may be ineligible for the position. Insufficient work history. In order to qualify, each state has a minimum criterion for the amount of work history required. During the time period of the claim, any money that you earn can have an impact on the amount of benefits that you receive. Gathering evidence. Strong evidence is essential to the success of an appeal. Here's what you need to gather. In the letter of denial, this explains the circumstance as well as the deadline for your appeal. In the event of a termination of employment, a notice of termination, paperwork for a layoff, or any other documents that pertains to your departure from your job. Documents in support. Did you leave your job because of the hostile atmosphere you were working in? Documentation such as emails, complaints, or testimonies from witnesses should be gathered. Keep a record of your job search activities such as applications, interview logs, or participation at job fairs. This will serve as evidence that you are actively looking for work. Documentation of income. If you earned money while receiving benefits, you should maintain pay stubs or other proofs of income. When the appeal is filed, every state has its own system for appealing decisions. The following is a sample roadmap. Take timely action because time is of the importance. When it comes to submitting appeals, the deadlines are often quite short, typically falling within 21 days of receiving the letter of denial. Examine the available appeals. The majority of states let appeals to be submitted in person, via mail, via fax, or online. Select the approach that is best suitable for your needs. Get ready to submit your appeal statement. Make it very clear why you are appealing the decision and why you believe it was improper. Remain true to the facts, be succinct, and cite the documents that demonstrate your point. Building a strong case. A few suggestions to help you increase your appeal are as follows. Pay attention to the rationale for the decision and address the particular concerns that were brought up in the letter of refusal. Stress the following factors that qualify. You must provide evidence that you satisfy the requirements set forth by the state. Ensure that you speak in a mature manner, be respectful, and steer clear of language that is accusing. Maintain order in your arguments. Please present your argument in a manner that is reasonable and easy to comprehend for the person making the choice. The appeal hearing. If your case is going to be heard, you should be ready for it. Adopt a professional attire. Initial impressions are important. Make sure to arrive early. Demonstrate respect for the procedure as well as the time of the adjudicator. Gather all of the documents. Make sure that your evidence is easily accessible. Please provide answers that are both clear and succinct. Stay focused on the facts and refrain from rambling. Respect others and behave politely. Maintain a professional demeanor at all times, even if you disagree with the decision that was made initially. Seeking legal assistance. You are able to represent yourself in complex instances. Nonetheless, you should consider hiring legal assistance. An attorney who specializes in unemployment law can learn to navigate the complexities of the law. The legislation governing unemployment can be quite complicated. Expertise in the law can guarantee that you fulfill all of the requirements. In order to present evidence, gather it. Lawyers are trained to construct compelling arguments and to convey them in an effective manner. Attorneys are able to argue for their clients' best interests throughout the appeal process and can represent their clients at hearings. Additional tips. Maintain your ongoing filing for benefits. Even while you are appealing, you should continue to submit your weekly claims. Making a record of your ongoing employment hunt is accomplished through this action. Take your time. The appeals process can be time-consuming. Preserve your composure and continue to be persistent. Learn from the mistakes you've made. Contemplate the reasons for the initial rejection of your claim. Your ability to strengthen your job search and future claims, if necessary, can be strengthened by this. It's not necessary for a refused unemployment claim to be the final word in the matter. Increasing your chances of having a successful appeal can be accomplished by first gaining an awareness of the process, then gathering evidence, then constructing a persuasive case, and last, possibly seeking legal assistance. Always keep in mind that unemployment insurance is a safety net that is designed to assist you while you are looking for work. You will be able to obtain the rewards that are rightfully yours if you follow these instructions.